Next, we're going to move to committee substitute for House Bill 597. Representative Stark, you are recognized to present your bill.
Good morning, Chair, members. Thank you for the opportunity to present House Bill 597. House Bill 597, the purpose is to clarify the procedure for the release of birth records in the cases of adoption when the adoptee becomes an adult. The bill authorizes the release of records to an adoptee if they are 18 years old or above, and the biological parent states in writing that their name may be released. And that is the bill, sir.
Thank you for that explanation of your bill. I see no amendments. Are there any amendments, members? Good, no amendments. Let's move to public testimony. We do have two, questions. Members, are there questions on the bill? Representative Schlossberg, you're recognized.
Thank you, Representative Stark. My question is, what is the difference? What is this?
Turn on, I think your mic's off.
Okay, thank you, Representative Stark, for bringing this good bill. My question is, what does this do differently than, how does this change the system?
Well,
You're recognized.
Thank you, Chair. The current law is interpreted differently. We had the current law analyzed, and the current law states that for an adoptee to receive a copy of their original birth certificate or birth records, that they must have a written release by both the biological parent and the adoptive parent. We did have some analysis here of the law in the House, and staff felt that you really only required one release just from the biological parent, so it was inconclusive the way the law read. So, the staff came up with a very good method of amending the law by just striking out this saying that, one person has to have it in writing for the other to get, in other words, so in this case, as long as the adoptee and the biological parent both sign a document that they want the record, they can each have it.
So I'll ask a question. So prior to this, there was some ambiguity in the statute on who could obtain a record and how. Is that correct?
That is correct.
And so your bill will address that.
That will clarify it.
We'll have a standardized process across the state.
Yes.
Okay, great. Thank you. Any other questions, members? Yes, Representative Roach, you're recognized.
Thank you, Mr. Chairman. Good morning. Great bill. One quick question. When you have two biological parents and one of them wants to authorize the release of records, one of them doesn't, is the name of the parent who doesn't simply redacted, or how would that work?
Yeah, thank you, Chair. In the majority of cases, the birth mother is always on the birth certificate. The question is, do they need the sign off of the biological father? And if yes, that there is that possibility that the name would be redacted. Generally, it probably would not, because in most cases, I can tell you my own case. As soon as I contacted my biological mother, she immediately told me who my biological father was. So in most cases, you find the information out anyway, so there's generally not a reason to do that, but yes, the name could be redacted.
Any other questions? Okay, seeing no other questions. Public testimony. We do have a couple of cards here. Bill Barrett with the Florida Adoption Reform and Education. You are recognized.
Thank you, Mr. Chairman. My name is Bill Barrett. I represent Florida Adoption Reform and Education. First of all, I'd like to thank Representative Stark for bringing this bill forward. It's been many years to get adoption reform legislation heard in the legislature. I came to this issue because my wife is adopted, and I'm meeting with some of the groups. That's how I came to FLAIR. I offered my services to them pro bono because of the personal issue of my wife being adopted. I can tell you in our case, my wife was 34 years old when she found out who her birth parents were, and at 34 years old, she could sign a mortgage for a house, she could sign for a car loan, she had kids of her own, but she had to go and ask her adopted parents to sign the piece of paper for her to obtain a document that their names were not even on. Now, we're talking about adults, we're not talking about children. And that's what this bill would address, so that in my wife's case, at 34 years old, there would be no reason to go back to the adoptive parents and ask them to sign. From statehood until 1938, birth certificates were not amended, and they were public record. From 1938 until 1987, the law stated that upon turning 18, that, quote, at the insistence and request of the person whose birth is the subject of said certificate of birth, provided, however, that before any such person shall be entitled to have the seal broken and the record opened without an order of the court, he or she shall first identify himself or herself to the satisfaction of the registrar. That was actually reaffirmed in court cases in 1976 and 1977. In 1987, the law was changed into what it is today. The process to go through before that simply said when you turned 18, you presented the birth certificate that you had to the registrar, and the registrar sent you your original birth certificate. No one's signature was needed. We, of course, like Representative Stark's bill, it addresses a problem that needs to be addressed. We would like to see the issue go further. We would like to see the issue go back to the way it was before 1987. DNA testing has changed this issue dramatically, because today there's 23andMe, there's all these different DNA tests, and every week I talk to adoptees who are doing these DNA tests. They're finding a first cousin or a second cousin or an aunt or an uncle, and that's who they're contacting. And then they're running sideways through a family tree to try and find out, hey, do you know anybody who had a child that they put up for adoption at this day and time? And that's really not a good way to do this, to run sideways through families. It's best that if there's going to be any contact, that it's directly between the two entities, and then they can decide what they want to do from that point. So DNA testing has changed this, and even though the law says they can't get it without all the signatures, they're using the DNA testing to find their families right now. The process that is also in this bill at the bottom that's not being changed, that you can go to court and get a court order to have contact made. In our case, we went to court. We got a judge to sign the documents that say we proved to them we should have it. We wanted medical information. We didn't want an original birth certificate. And the judge agreed with us. We went through the whole thing, and then we found out years later that DCF, in fact, never made contact with the birth mother. They made contact with the birth grandfather because DCF still considered that even though she was underage at the time that my wife was born, they still considered her to be a child today and didn't contact her. They contacted the birth grandfather. So the system as it sits is broken, and we found that out years later. And that's part of the reason why we would like to see it go back to the way it was before 1987. And with that, as I say, we support Representative Stark's bill. I'd be happy to answer any questions that the members might have.
Thank you for your testimony. Members, do we have any questions? Seeing none. Thank you.
Thank you, Mr. Chairman.
We also have Barbara Devane with Florida Now, who waves in support. And that concludes public testimony. We're now in debate. Members, is there debate on this bill? Seeing none. Representative Stark, would you like to close on your bill?
Well, just thank you, sir. Just thank you for the opportunity to present this issue before the legislature, and I ask for your favorable support.
Very good. Please call the roll on committee substitute for House Bill 597 and announce the vote.
Representatives Brown? Yes. Burton? Yes. Cortez? Yes. DeSegli? Yes. Dorian?
Yes.
Goff Marcel? Brandt? Yes. Jones? Yes. Leek? Nagar? Yes. Pigman? Yes. Plakin? Yes. Ponder? Yes. Roach? Yes. Schlossberg? Yes. Stevenson? Yes. Yarborough? Yes. Chair Rodriguez?
Yes.
The bill passes.
We will show that bill reported favorably. Congratulations, Representative.
Thank you, Chair.